welcome back to another episode of the Daily Flip podcast. I'm your host, Alex, and today we're going to be flipping through a story coming from Jacobin. And they're speaking about how the Donald Trump tariffs are going to probably be overturned by the Supreme Court and why progressives should not be happy with that happening. With that said, we're going to jump into our daily debate. Are the tariffs an overreach in Donald Trump's executive powers? Throw your opinions down there. I've asked this question before. It will come in context very quickly as to why that's an important question and whether or not it's worth the Supreme Court doing what they're doing. So, with that, let's jump into the article. The headline for this Jacobin article reads, Trump's tariffs defeat spells long-term danger for the left. So, for a long time, I have been very openly free market and very openly anti-tariff, especially during Donald Trump's time. The reason Jacobin is so scared that they're quivering in their boots is because the reasoning, the logic, the legal perspective which the Supreme Court will bring to bear will actually limit the power of executive agencies and the executive as a whole. Why is that a bad thing? Because very often these regulatory agencies are used in a blasé way by any given executive, Donald Trump, Joe Biden, Obama, Bush, so on and so forth, in order to fulfill the mission that they believe they have been elected to uphold. And because Congress doesn't do much, they write in very broad interpretations, or at least non-specific interpretations, of what these regulatory agencies can do. Therefore, they give these executive agencies a lot of latitude, and the Supreme Court is coming in and saying, well, maybe they shouldn't have as much latitude. They've struck down Chevron before. They've struck down a lot of different cases saying that executive agencies don't have as sweeping authority as the Congress has abdicated and as people have implied that they have. And what is the legal doctrine that this this methodology of approach comes under? Quote, although at first glance a decision based on this logic does not appear dangerous, the recent history of the major questions doctrine demonstrates its potential to empower an unelected and highly conservative judiciary to obstruct social progress. A ruling against the Trump White House would further entrench this menacing legal principle. So, where are they actually coming down on this issue specifically? Why can they use the justification, or at least have a framework of major questions? Why can they use it? Well, here we go. Quote, as the liberal Supreme Court justices pointed out in these cases, so the two that we're talking about here are United States Trump versus Learning Resources and Trump versus VOS. As the liberal court justices pointed out in these cases, the major questions doctrine essentially imposes a clarity tax on the legislative process. Congress must legislate with a level of specificity that it is usually impossible to achieve, and federal agencies are stripped of the autonomy and discretion required to rein in corporate power. Now, that last part of it is obviously Jacobin's spin on what these agencies are allowed and not allowed to do. And if you see them as tools to stop excesses in the market, to stop people from being taken advantage of, from corporations from stepping in and going beyond their natural purview and affecting the social well-being of a country and a society, then of course that makes sense. And if you're a conservative, you'll say, well, they're very often stepping on businesses by imposing regulations, and they're restricting the free market by trying to crack up monopolies. Or you could even make the argument that they are imposing health restrictions or enabling health restrictions that will limit the power of the family, or at least the importance of the family moving forward. So you can see how both sides could come to a place where they have their very specific opinions on the executive agencies. But also, there's a world in which it actually makes sense for liberals to say that they do not want an executive to have these sort of powers in places where the state has overreached and they're able to use executive agencies to enact tariff policy, to enact border control and immigration restrictions, the levying of different restrictions on visas. And there's a list from there. And conservatives could say the exact same thing. These agencies could actually provide backdoors for child tax credits in order to encourage more children to be born. They could levy protectionist, and this is not all conservatives, but some conservatives do believe still in protectionist policies, and some liberals do as well, which allow for the protection of unions and for local domestic economy. You can see how both sides would come to this point. The reason Jacobin specifically in this case, specifically, is frustrated and is not okay with it, in my opinion, this author who wrote this, is because the judiciary is conservative. If the judiciary was more liberal leaning, more progressive, I don't think there would be any issue with it. It's not actually a matter of principle, it's a matter of politics. And of course, in Washington, that's how it always works. But why can I say this with confidence? Because they use words such as social progress. That sounds like a very principled thing. And yet, in a world in which Congress constantly abdicates its power and more power is put in the hands of the executive, you need something that is able to balance out the the most extreme positions of any given president. And if it were a progressive court and they were doing it to Donald Trump and they were allowing more progressive social change in different interpretations of the law under the exact same framework, saying, well, actually, can the president restrict this? Why would they not actually have a broader mandate? Because they need to make sure that this major question is addressed in at least the formal understanding. And let's be clear, I'm actually inversing the logic that they're proposing here. But a major questions doctrine, why does it not allow for a more generous interpretation of the law? Because it is such a major question. It is one that must be addressed. I think that's stretching, but my point being, if there's a progressive court, I think Jacobin would be more okay with them stretching in order to do so, where the conservatives are definitely attempting to stretch their original interpretation of the major questions doctrine, and it's constantly being redefined and reused and codified during this judiciary, which is another reason. Because it is in front of the public, because it's in the front of Jacobin, that's another reason they're aware of it and they are not happy about it. So what is their end all be all? What's the end point that they reach here in this article? Quote, leaving aside the fact that the framers of the U.S. Constitution had no real conception of capitalism, gave the federal government formidable tools to regulate the economy, and detested the prospect of concentrated economic power, the left should obviously be troubled by legal doctrines that empower an unelected judiciary to insulate oligarchs from even the most minimal and half-hearted challenges to their wealth and influence. Far from being celebrated, a defeat for the Trump administration in the tariffs case should revive the classic leftist position on the judiciary. This is a foe, not a friend. And that's a fair enough interpretation for them to have. I think it's a fair enough interpretation for everybody to have. I think is probably the best interpretation, which is even the institutions that are meant to codify and protect your rights can be used by ideologues on either side to actually infringe upon your rights. You think back to when the conservative court actually went against what most populist conservatives would have considered a win when they said that it is actually okay for the government to actively work with and collaborate with social media companies. Did they say to the extent at which they can mandate that these companies take content down? They didn't explicitly say no, though they very obviously said that should not be the intent of any of this. But that is something that conservatives were deeply frightful of underneath the Biden administration in the Twitter files when they came out. They were looking at it and saying, whoa, 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 the administration is talking to these social media companies. That's unacceptable. And yet, Kavanaugh and his coalition of federal believers turned the court case on its head and went against what the conservatives would have wanted. That's not to say that's a good thing that they're pushing back. It's not to say that's a bad thing that they're pushing back. It's to say that any government institution, anything that has the power to strip you of your rights, freedoms, and your basic, not even quality of life, the most basic principles in which that enable you to live a life unencumbered. Let's put it that way. Not vague at all, not a platitude at all, definitely not. They should be doubted, questioned, untrusted, and they should be foes in your mind. Not in violent ways, not in ways that you try to tear them down, but you should always be skeptical and you should push back against their power. But hey, that's just my opinion. So, with that, if you want to listen to today's entire episode, you can find it down in the link in the description below that like and subscribe button. Also, down there, you can find the podcast on Spotify, Pocket Cast, Podvine, as well as the Twitter handle at your Daily Flip, where I post these episodes on Monday, Wednesday, Friday, and the 6 and 6 on Tuesday and Thursday. And 6 and 6 is all about getting 6 stories from around the world in 6 minutes or less to international news. So, with that said, there's only one more thing to say. Stay safe. Don't die.